Good day, everyone. Richard Cowperthwait for Northwest Access TV. Thanks for joining us. And we're happy to have alongside myself Jim Hughes, the former Franklin County State's Attorney. Had an hour interview a while ago. I thought that went pretty well, and I thought we could knock off another hour pretty easily. Jim, thanks for coming back.
Why, absolutely. Thank you for having me.
Trashing your morning too much. Sounds like you have some house issues to deal with, but I guess they'll be there when you get back, huh?
Yes, they will. It's nice to be retired. I have time now to do a lot of things that I didn't before.
That's great. So is this real retirement on from a work point of view?
Yes. Yeah. Yes. Right now, I'm just doing things around the house, which is a very, very old house, so there's a lot of things to do.
How old is that house?
140 years, 130,
again, the
something
old
like that.
Percival Shangri House on High Street?
Yep, Justice Shangri lived there. Wow. It was the carriage house for the house next door, which is a big mansion-type thing on the corner of High and Bank Street.
Right.
And they had moved it back from the background of that big house down to face off in St. Albans on the street. And it's, we moved in at about 1996, I think it was. And raised the kids there, and it's still at it.
Yeah. No, it sounds like a good place, nice part of town. Mm-hmm. So real retirement from a work point of view.
At least for now. I'm not bored doing nothing, because I'm really I'm not doing nothing. But,
I'm sure.
But I don't have to get up and report to work or clock in anywhere quite yet.
And that's feeling pretty good, huh?
Yes. Yes.
In fact, speaking of that, will you keep your law license? Will you keep that active, or no reason to do that? Or
well, that's a thought right now. I haven't made up my mind.
How often do you have to do whatever you have to do?
I have one more year.
Okay.
Your license is good for 2 years.
Okay.
And so if I keep up on the continuing legal education, because every year a professional has to have so many hours of CLEs to then be able to apply to keep their license.
Yeah.
If I do that, I may. But, it's been 36 years, essentially, of having everybody else's problem be my problem.
Wow.
And I think that's a long time.
Well, that is a long time. So, but you're pondering that. So
yes.
You have another
who knows?
Year.
If something comes out, it'd be great.
Yeah.
I may find a way to ride around a golf cart and put divots back where they're supposed to be. And, just make sure the summers go by and the winters go by somehow.
And is it inconceivable you ever do any work, say, as a deputy prosecutor, if they needed you to jump in for like a case or two? Is that conceivable?
Probably not.
Probably not.
Probably not. But I don't get unsworn as a officer of the court. I as a law enforcement officer, essentially swore to uphold the Constitution and took that away.
Yeah.
Just because I retired, that's not over and done.
Go anywhere. Yeah.
But I don't know that would happen. They've got a full staff now in the Franklin County office.
Yeah.
We'll see what's up.
Yeah. And speaking of which, of course, you supported John Lavoie.
I did.
Who was a deputy who did win election, of course. And
yes.
He's, at this point, obviously the state's attorney-elect, acting state's attorney, is that, or interim?
Interim or acting, I think.
One of the two.
One of the two. He's going to be sworn in January.
Yeah.
And then it'll be completely official.
Interesting. You feel the office is in good hands with Mr.
I think so.
Lavoie? Yeah.
Because it's a good team.
Yeah.
He works together with
and no other
the other
changes
deputies.
in all the other deputies are hanging in?
As of now, yes.
As of now.
Yep. And we had a new hire just as I was leaving in September, and she seems to be working out also. So
yeah.
We'll see. I don't have my finger on the pulse anymore.
Yeah.
I go there maybe once a week to say hi and to pick up mail that I haven't changed the address for yet.
I suspect John would track you down once in a while about a case, or hasn't.
We'll see.
We'll see.
There's a couple that we've talked about since I left, but he started essentially the same year I did.
Oh, yeah.
In the southern part of the state, has a lot of experience and there's a lot of experience in the other deputies too.
Yeah. Do you see a different style? Obviously, you know John Lavoie very well. I mean, I guess that every state's attorney has his or her own kind of style, or some differences probably in how they'll run the office. We'll see.
And probably, I haven't really, you know, I don't go to the court to watch the proceedings or to view any trials. And like I said, I'm not going to hang around the office and say, gee, I would have done it this way.
Yeah.
You know, it's not my office anymore. My name's not on the door anymore. So it's, you know, up to those guys. And I've convinced myself that other people can do my job.
Yeah.
So
interesting. So you were successful in backing John Lavoie, who was victorious in November. We talked about this, I think, on the first show. And for what it's worth, we're taping the show on Thursday, December 8th, day after Pearl Harbor Day, for what that's worth. I mentioned that when I'm talking to current people in case anything crazy happens, and they're wondering why we didn't talk about it. Presumably not the case with yourself.
Hopefully not.
So when you did back, the Chittenden County situation, I wake up to the WVMT folks every morning. And Kurt Wright, of course, former legislator, Burlington City Council president. I mean, those folks are just, the Burlington situation really does sound pretty concerning. I guess fifth homicide the other day, top since 1990. Just the shoplifting cases. I mean,
tough.
it just but I was going to say you did back Sarah George, the Chittenden County State's Attorney, her opponent in the Democratic primary,
right?
And Sarah George won, I think, the primary pretty easily and had no opposition in November. But and again, was that, we've talked about this before, was that a kind of an unusual step for you? Had you ever done anything like that before?
I had not. I hadn't ever really thrown any my name in the political hat except for my own.
Right.
And it had.
And for the record, you never had an opponent.
Right.
Amazing.
For 8 elections, I voted for myself, and that would have been enough. I think. But no, I did back Ted Kenny. I know Ted, and I think he's got a good head on his shoulders, and he looks at law enforcement a little more like I do. Yeah. And although, I mean, Sarah George is very bright and persistent in getting her points across.
She
I disagree.
She was appointed by Governor Scott,
That's right.
Whoever had left the state's attorneys.
I think it was Bob Simpson.
Oh yeah, Bob Simpson.
But Sarah George was appointed. Yeah. Now she's elected.
Yeah. Was this her first? Was this her first election?
I believe yes.
Okay.
And I admire her persistence.
Yeah.
I don't agree with her philosophies. Yeah. And I don't agree with the way she's looking at what she calls the law enforcement reforms. Yeah. And I don't think that a lot of the citizens of Burlington are going to agree if the trend keeps going the way it is.
Yeah. Of course, Kurt Wright's line after Ted Kenny lost the primary pretty easily was, why did you run in the primary? You should have run in the general election, but who knows if that would have been any different.
Right, but that wasn't my call for Ted.
Right. But boy, the Burlington just sounds like a tough situation. I mean, the shoplifting issue just blows my mind. Yep. I'm hearing, you've probably heard the same thing, outdoor gear exchange. I think I heard they're losing, did I hear $20,000 to $40,000 a month? I mean, and of course, LL Bean pulled out of there and went to a new store in Williston, supposedly because of shoplifting concerns, among other things. But
and among other things, it's kind of tough to get your clientele to continually shop when you're right next to a big old hole.
Right. That probably didn't help. But the shoplifting, if you shoplift for under $900, it's just a misdemeanor. That's accurate? It takes $900 to kick it up to a felony?
It was 100. And then several years ago, the legislature decided to raise it to 900. Really? Partially because of the electronics boom. Oh, yeah. Little tiny watches and phones and things like that were over $100. Yeah. And people would put them in their pocket and walk out. Yeah. And then get convicted of a felony that would stick to them forever. Yeah. Of course, nowadays, felonies don't stick forever with the expungements after a certain period of time.
Right. Even for felonies.
Right. And the legislature decided that, shoplifting, stealing from, our local businesses was not worthy of a felony conviction unless it was a real large amount of items taken. Yeah. But now with the prices of things going up, you can still reach that $900 limit pretty easily. Boy, but it's it's always been bad. There's some commercial shoplifters out there. People go in and just clean out an aisle's worth of something, and then it's on the secondary market within minutes.
Really?
But and again, there's also always the sort of self-preservation types that just think they need their food or whatever supplies more than the store needs to make money.
Yeah, and then of course the Burlington Police situation getting attention all the time. I think the stats, they've got about 62 officers, but just 50 or so able to go out on and do their thing. But
they're stretched very thin. It's a tough spot to be in.
Yeah. Franklin County hasn't, it's a pretty different world up here, but hasn't run into that so much. Was pretty much stable.
It's not immune. We're not immune to things like that.
I'm sure.
The state police are stretched very thin.
Boy, sounds like it.
Chief Lamoth is always looking for more able-bodied, trainable people who want to be in law enforcement.
I guess as everybody
Swanton,
else is too, pretty much.
as is filling its ranks.
Yeah.
And the sheriff's department, yet to see what's going to happen.
Yeah.
After that election. So.
And I guess speaking of which, hard not to talk about that a bit. Do you see the sheriff situation as a salvageable situation with John Grissmore? I've got a little bit different take. I had my first interview with John. I bumped into him the other day, talked to him for about a half hour, and he's moving ahead. He said he's met with staff, and most of the folks are hanging in there. Of course, he's got a simple assault charge hanging over his head, which he said there's no way I'll get a conviction of that. Of course, he told me he didn't think there was any way he'd be charged in the first place.
Okay.
But let's either way, it's a misdemeanor charge. It's not like he's out of being sheriff if he gets convicted. I guess that's apparently that's irrelevant. There's been some at least loose talk, I guess, about impeachment, possibly. I think Senator Brock's mentioned that. That sounds like a very extremely tough thing to pull off.
It would be hard. It would be expensive.
Right.
And it would.
That's hard.
I don't know what effect it would have on the Franklin County Sheriff's Department.
Yeah. But again, you're now the former state's attorney. But if you were still state's attorney, is it from your point of view? I guess salvageable is a word that comes to mind with such a heavy cloud hanging over his head. Of course, he says he acted appropriately. Right. I don't think a lot of people buy that, but that's what he says.
And one thing he has on
you had dealt with him, I assume, as state's attorney.
And so what I did when that came to light, and I saw the video.
August 7th was the incident.
Talked with the investigating officer, because it was a state police person assigned to investigate. We chatted a lot, and the Franklin County office was not going to get involved. I wanted to see what was happening, and I wanted to look at the affidavit, but I wasn't going to make the charging decision because I had dealt with John Griswold for a long, long time.
And indeed, John Lavoie kicked it over to Doug DeSabato in Grand Isle County, who didn't bring the simple assault charge.
Yep. And a charge is a charge. So a judge has found probable cause. But he's innocent until proven guilty. And there's a lot of things that can happen between now and a trial day. I haven't put my fingers on any of it, and I don't want to be involved in that. But I can see his point of view. And
what he told me, and I'm obviously no lawyer, but he said, Richard, there's no way I'm getting a conviction because the detainee, the quote victim or would-be victim, there was no pain. I guess said person, I think later on said there was pain, but is that a standard for simple assault? He said there's no pain, so there's going to be no conviction.
Well, there has to be bodily injury. Simple assault is either purposely, intentionally, or recklessly causing bodily injury to another.
Bodily injury.
And bodily injury, one of the definitions of bodily injury is pain.
Okay.
So if, the situation where, you have the bar fight and one guy hits another guy in the nose, and the guy who gets hit in the nose says, well, you didn't hurt me. Well, that negates a criminal charge for the guy who hit him in the nose.
Right. From what you know, were you surprised that simple assault charge was brought? From what you're certainly pretty familiar with the situation.
No, I think the probable cause is there. I didn't read the final affidavit, so I don't know what the alleged victim had to say about being hurt or not.
But you weren't surprised that a charge was brought.
No.
Yeah. No. And that seemingly from the incident was the obvious charge. There was no other charge that comes to mind, or not the case?
Well, like I said, because I wasn't going to make the charging decision, I didn't really look into alternatives.
Gotcha.
But there's a lot of, the video itself is pretty compelling.
Yeah.
And I know that State's Attorney DeStavato from the islands is a by-the-book prosecutor.
Yeah.
And if he sees that there's the elements of the offense, he'll bring the charge.
He was also flashing back to the Sarah George, Ted Kenny case. He also, like yourself, was backing Ted Kenny, was he not?
I believe so, yes.
I think he went on record doing that.
Yep.
Gee, it's, again, law enforcement, it's just a tough, it just seems like such a cloud hanging over the sheriff's department at this point.
Well,
but again,
they're not alone because, the pendulum of, defund the police and take all the pseudo-military, vehicles and equipment away from them. The attitude of not wanting the police to do their job, the Department of Corrections to do their job, probation, parole. The pendulum swung very far off of the line it should be, I think.
And very different going back to your earlier days. Is it just a very different world? Was it just where police just held, you just didn't have these issues years ago so much anyway?
Well, the public tended to back law enforcement. And police officers, most of the time, acted, well and compassionately and within the boundaries of the law, and were trusted. Even, in the days where a police officer might bring a young adult back to their mom and dad and let them know that he was flirting with a criminal charge or whatever, and let the families stand up and deal with that. There was more respect for law enforcement, even if law enforcement didn't involve the courts and corrections and things like that. Those days, because of liabilities, an officer who nowadays an officer makes a car stop, they at the very least have to issue a written warning, so there's a paper trail of what happened.
Is that right?
And now
they have to do something
in a lot of departments.
Really?
And the body cameras are recording to show any interaction with the public, especially in those traffic stops. There's checks and balances now, but there's not the same sort of, trust of law enforcement. There have to be checks and balances. But
do you think that's maybe starting to go back, as you say, the pendulum having swung so far, it maybe come back a little bit?
I sure am hoping that it swings soon because, as you see in Chittenden County, there's and a lot of cities across the country are showing the effects of defunding the police and not backing law enforcement or allowing them to do their job to the fullest. Because. And maybe there's some good reasons there to try to bring certain citizens, certain groups back into the fold of being a good citizen, being Americans, being productive members of their local society, and not being disenfranchised and think that no matter what they do, they're going to be just hassled and arrested and jailed. But I don't know that bail reform is the answer. I don't know that,
that's
sentencing is
probably a big issue everywhere. Certainly in New York, that became a big issue.
Oh yes, and
again, can you get into to that a little bit again? Just talking bail, I think a lot of people, probably myself included, aren't totally clear on bail, but the key with bail is in ensuring the defendant shows up in court for the next hearing, as opposed to whatever this person did have serious. Or not that
There's two ways that a person is addressed by the judge when they're arrested or appear in court because they've allegedly committed a crime. Probable cause gets found, they get arraigned, and as part of that, they enter a plea. They apply for a public defender or have a attorney of their own or represent themselves. But before they walk out of the court, typically on the request of the prosecutor, there's the risk of flight to avoid prosecution is looked at. And if there is a risk of flight, then cash bail can be imposed. And the other thing is the potential for conditions of release to protect the public if the judge decides that this person is a risk to either reoffend or interfere with the potential witnesses, or even just continue with other offenses. The judge can impose a pretty wide array of conditions of release that could include no contact with certain people, no alcohol, no drugs, curfews, geographic restrictions. You can't leave the county or can't leave the state, things like that. And so the bail itself is just to get the person to make sure they come back to court. And then the potential for conditions of release, if they're related to the offense, can be imposed to sort of restrict the activities of that person. And both bail and conditions of release are being used very sparingly in the legal system now.
And there was a feeling, just the BIPOC people of color issue coming into play, saying, hey, it's so disproportionate. The people of color are the ones being held on cash bail. I mean, that seemed to factor into some of the bail reform measures.
Well, that is an argument being made. In Vermont, in my experience, people of color that don't live here, that come from other cities in the Massachusetts area or New Hampshire or Montreal, Boston, whatever, that come up to Franklin County to commit crimes or to try to make money in the drug trade and are arrested, don't have ties to the community. And if
so, why are they going to show up again if they're
not without at least some sort of a surety or cash bail? So the population from out of state that comes into our state to commit crimes, I think, is ripe for bail. But with the bail reform pendulum swinging the way it did, really, in my experience, cash bail hadn't been set in the last few years in an amount that would really make somebody want to come back and see their cases through.
Is that right?
It does happen. And when we lose people in those big metropolitan areas.
Jim, boy, a lot of years, again, 3.5 decades or so. Did your job change? Did the job of state's attorney change a lot over that time?
Well, I mean, a lot of aspects of it changed. I mean, it's still not much changed in the Constitution. There were some new laws, obviously. I mean, just in DWIs, when we had the crimper back, that would actually capture some breath in an indium metal tube, and then that tube was sent to the lab, and the actual breath was analyzed down in Montpelier or in Waterbury.
Boy, now that you mention that, I can just back in my reporting days, I remember a few years DWI was really under attack by defense attorneys, and maybe for what you're talking about.
Right. Well, when it
just
changed,
saying, hey, this is bogus, and throw out all these cases.
Right. The attack happened when the state went from this gas chromatograph analysis of the actual breath in a tube to on-site infrared breath analysis by the BAC Data Master. And so the
Data Master, that rings a bell.
There's a change in technology or in some sort of a law enforcement technique, there's always going to be a test, usually brought on by the defense attorneys challenging in court the science behind it, or the operation and the training of the people who do the work on the machine.
I remember that.
That was a long battle. I mean, but just as an example of how things changed, when I first started as a deputy back in 1987, they walked me into the office, and on my table was an IBM Selectric typewriter and a brand new box of paper and a brand new box of carbon paper.
Wow, really?
And the Selectric at the time was the state of the art. I was happy as could be. But after a few years, then they replaced that with a computer. And then we've advanced since then.
Is there still paperwork? Is everything done on computers now? Is there still some paperwork?
They're working on it. It's a slow evolution. But yes, there's still paperwork. We're trying to become paperless. But it's hard to do. I mean, the trials The court is asking for thumb drives or discs with any evidence that's digital, photographic, things like that, to be filed before the trial starts. But then you're still going to have some attorneys coming up with a picture for the witness to see and the jury to see, and so you have it sort of duplicated when it's the intent is to get it all paperless, but it's a long learning curve.
Interesting. Did your job get more difficult? Did it get more difficult? I mean, it sounds like a tough job to me, but did it get more difficult over the years for whatever aspects of it changing, or?
You still have your basic, the state brings a charge. The state's attorney reviews the police work, decides whether to bring a charge. The judge finds probable cause, and then you have a trial where the state has the burden to prove the elements of the crime beyond a reasonable doubt.
That hasn't changed.
Hasn't changed at all. And the defense's job is to make sure that the defendant gets a fair trial. Some defense attorneys take the next step and say their job is to get the defendant off by suggesting doubt, no matter how far off center field that doubt might be. But you still have a trial where the standard of proof is beyond a reasonable doubt. The state has the burden. And sure, we've advanced a lot of investigative techniques. I mean, DNA technology, the data masters, infrared, a lot of drug analysis things have been advanced with the science over the years. But you still have the same technique. You have to bring the scientist in to explain to the jury what the problem was, how they solved the problem, identified the object or whatever, and whether that was a legitimate scientific way of doing it. And the jury can say yes, the jury can say no.
In your view, did Vermont make a mistake by making pot and marijuana legal? Was that something you weren't happy to see?
Well, we're yet to see. I mean, the supposed I guess we're just now getting cannabis shops and showing up in some places. Right, it's now starting to be retail around Vermont, where you don't need a medical card. But I think the research into the medical uses of cannabis has been ongoing, and I believe our legislature believes that there's some medical use, so that there has been for a while now the medical cards, the medical marijuana dispensaries, and the ability to, as a patient, use marijuana to treat whatever ailments that's prescribed for. But now with the recreational stuff, I'm not a big fan. I think that there's a downside. And I think we're going to get to see that.
No, the governor's one of his big concerns was just driving, obviously. I mean, we're talking about DUI, DWI, where seemingly you can nail that down pretty well. But a big concern was, boy, if someone's just high on marijuana and stuff, not so easy to nail down the impairment issue.
Correct. There's ways to detect whether there's THC in somebody's system, but there's no set number like a 0.08 alcohol that says that this person is impaired by marijuana to the extent that they can't operate a motor vehicle safely, which is the DWI drug standard. Not the DWI alcohol standard is impaired to the slightest degree.
Impaired to the slightest degree.
Impaired by drugs is to the extent that they can't operate a vehicle safely.
Interesting. Is it 0.08? Is that, I haven't heard that for a while, but I know there was a push by at least probably some legislators to lower that. Haven't heard that for a while. Would you like to see that lower? Is that about where that should be? Or
I think it's the system set up fair right now.
And that's pretty typical for states, I think, 0.08. Is that
That's pretty much, there are different situations where the test could be lower, and somebody would be guilty of DWI if they're underage or a commercial driver with a CDL. And I don't have my Title 23 in front of me, but I think it's a 0.02 for a CDL person to run into trouble if they've been drinking and operate their commercial vehicle. But back to the marijuana part, yes, the driving is a big concern. And we're starting to see more numbers with the drug recognition experts, the officers that have undergone the special training to be able to identify when somebody is under the influence of some kind of drug through interviews and physical exercises and observations. And it was getting more and more prevalent. Just when you combine the potential, and I know there's an age limit for legal use of marijuana, and there's research that talks about the development of the human brain, and that adolescents really aren't adults at 18. Their brain is still developing until 25 or so, and even if they start legally and they obey the law and wait, but then decide to start smoking marijuana recreationally at 21, there's still some years of development in that brain that are going to be potentially affected by their use of THC, and we're not going to see that or see the results or know until time passes, and more studies are shown, and we know what's going on. So I'm not a real big fan. I don't think that it was the smartest thing to do to make it completely recreational. We'll yet to see what actual income that brings to the state for taxes and license fees and all that stuff. But I think that we didn't need to rush in to just beat New York or Massachusetts or New Hampshire to the punch to get money out of marijuana sales. And we'll see.
Interesting.
I don't oppose, just on that same thing. A lot of people are getting their convictions expunged, and especially misdemeanor marijuana convictions carried a huge penalty, disqualification for student loans, a permanent record that made a lot of employers and military service sort of out of reach for somebody who had a misdemeanor possession case. And with the expungement law, the states now expunging those, erasing them, sealing them, making them non-existent. And I think that that's not a bad thing.
I was going to ask you that. So you think not a bad thing?
Right, because
I'm sure the
punishment for a misdemeanor marijuana possession conviction, I thought was proportionally wrong.
And what was that? What was the sentence typically?
Typically, it was a first offense would be diversion, and then it'd be expunged anyhow. But if it's a second or third offense, it'd be a fine. I mean, it was rare that somebody got even a sentence that was probated because of misdemeanor possession, which is under 2 ounces.
Is that right? Under 2 ounces?
It was. I mean, now there's been changes with the legalization. They've changed the whole possession. Cultivation, and sales type of the scheme of the statutes. But for a long time, possession of marijuana under 2 ounces was a misdemeanor, and it was typically a fine. But it was on the record, and the collateral consequences caused a lot of people heartache. And like I said, one of the biggest ones was disqualification for student loans.
And jobs obviously figured in these days. I mean, talk about labor shortage, and talk about a huge issue. Everybody seems like they're looking for. So in some cases, those convictions would have caused somebody going after a job, I assume.
Well, that's why our legislature started.
That's where kind of the expungement came
allowing
from.
the expungement. It was improving the labor force, and in some cases reinstituting laborers who, because of the choice they made and the misdemeanor they were convicted of, may have been limited or excluded from a lot of the work that was out there. So that's changing, and that over for the past 6 months of my work life in the Franklin County office, we were getting expungement requests by the dozens every day.
Really?
And I know they're still coming in. So.
And the Attorney General, the former Attorney General T.J. Donovan, was certainly involved involved in that.
Right, and although I like to look at what people are trying to expunge.
Yeah.
Because typically we rubber stamped the misdemeanor stuff, especially if it was 10 or more years old.
Yeah.
Because even when people serve time, you serve your time.
Yeah.
And you pay your debt to society, and then you go on about your business.
Yeah.
You'd have a record of that, but supposedly the debt to society was done.
And even obviously some felonies you're not going to get expunged, but some felonies are expungible.
Sure. Yes.
Yeah.
And those are the ones that state's attorneys want to look at and make sure that the victims are on board. If there were victims, typically if there's a victim of a crime that was violent, I would not have agreed to an expungement. A judge might sign off on it above my objection or over my objection. But, I think there's some standards there that, some crimes, when they're committed willfully by people, those people are convicted, they should carry that along and be labeled as that kind of a criminal. There's a lot of industries. I want to just as an example, the insurance for motor vehicles. I mean, if you have 4 DWIs on your record, but you've done your rehabilitation and your 2 years of notarized sobriety, and you can get your license back, that's great. But you still might be a risk in the eyes of the insurance company. But if you get those,
probably pay a fortune for insurance.
Right. But if you get those 4 DWIs expunged, and the insurance company doesn't see them when they run your record, then what's the effect there? If there's somebody falls off the wagon, reoffends, causes damage. I mean, there's all sorts of bad potential there.
Speaking of DWI, I think I'd know this, but is one DWI conviction, is that enough to prevent you from crossing the border and going to Canada? Or did I dream that up?
No, I don't think
I've run into that. Boy, that sounds pretty... I remember thinking, gee, if I was an elected official, I'm sure I'd get a ton of support. I'm kidding, but that just seems pretty harsh to me.
Well, even if you weren't a minister in Quebec or Ontario, it wouldn't matter what you wanted to do to let Americans go to Canada, because Canada can say no. This is my border, and we don't want you careless and negligent drivers or you drinking and driving people from the States to come up here.
But is that the case?
It had been. I mean, I haven't looked very recently because the borders have been shut.
A DWI conviction you could not cross. You could
for a period of time, and it might have been 5 years.
Oh, really?
And even if a careless and negligent operation conviction happened, that could also bar you.
CNN could do it too. Interesting. Yep. Jim, talk caseload. I think a lot of folks just have maybe no clue, just the numbers you're dealing with. And again, in my reporting days, I would pretty much show up in, district court, criminal court for the Monday afternoon arraignment sessions. But caseload, have you got recall the number of pending cases the state's attorney's office has at this point?
I don't know about has at this point because it's been since September.
Sure.
I don't have my finger on the pulse.
When you were still on board, rough
figures? We were an attorney down. I had my Title 23 attorney leave, and I couldn't replace her for a period of time. So I was doing the DWI, DLSs, things like that. And that blew the numbers of my pending cases
way up.
over 12 to 1,300.
Is that right? Pending cases that you were dealing with?
Yes. Most of my deputies have somewhere in the range of more than 500 cases.
Is that right? So we're talking several thousand easily here.
And it ballooned when the court was shut down, and we're trying to do it just on the computer because it took 4 times as long to do anything while you were just doing it online and remotely.
Right. I wasn't even thinking about the pandemic issue.
Yeah. So that went.
And of course, obviously, not showing up in court, no trials, obviously, for a while, right?
That's correct. You can't put the jurors, they have the civic duty to be a juror, but not to risk their health and well-being to be a juror. So there weren't trials for a long time. There's no movement for especially the motor vehicle incidents, unless there was, bodily injury or things like that. it didn't get much court time, and that led the court to actually dismiss something like in the first move. And I don't know if it's happened again, but it was talked about. There were something like 1,200 DLSs and low-level misdemeanors, attempted retail thefts, where people didn't get away with it, type of thing. And merchandise was returned to the store.
So a ton of
those
these
were dismissed
cases
and just gone. And frankly, I didn't have an argument with that.
Yeah.
The judge warned me. We had a meeting that this was going to happen.
Yeah.
And he took my input on what kind of cases could, have the least effect that I saw on the system, and not, reward people's bad behavior. And especially with driving license suspended cases, there were a small percentage of people that had just kept riding around without their license and had 7 or 8 or 10 DLS charges pending.
Yeah.
And frankly, if they took their time in the year and a half or 2 years of the pandemic and addressed their issue, paid off their old fines, got their license back, I would have dismissed their cases anyhow. Good job. And if the person didn't bother to address their licensing and their cases were all dismissed, but they still were driving without a license, I'd probably see them within 2 weeks on a new case with a fresh docket number. And we can deal with it that way without, a huge judicial backlog.
See, I'm recalling a conversation, I'm going back decades, with John Edwards, then state police commander out of the St. Albans barracks. But I wish I could remember the stat, but I remember decades ago John telling me, Richard, you wouldn't believe how many DLS cases or drivers out there with DLS charges, and I think it was in the thousands. Whatever he said totally blew my mind.
It's a bigger percentage than it ought to be.
Yeah.
Because most DLSs are caused by failure to pay.
Driving while
first,
license suspended.
Bad driving, getting tickets, and then not paying the tickets.
Yeah.
There is a group of, or a category of driving license suspended that is caused by a DWI,
Right.
or one of the big 10-point moving offenses, attempt to elude, careless and negligent driving, leaving the scene of the accident, things like that. Those cause an immediate suspension. But the DWI ones, people put off taking the crash course or the impaired driver improvement program, whatever the acronym is now.
Yeah.
But and then start driving again before they get reinstated and risk that DLS. Those people, I think, need to be addressed a little more harshly than somebody who's just had some tickets and not paid them, or is on a payment plan and skipped a payment and had their license suspended.
Yeah.
We'll see. But most of those were the ones in that 1,200 that the court signed off on and said goodbye to.
It just sounds like a staggering number of cases. Tell you about it. You're dealing with it forever, but
yep. And
is that pretty typical for the state? Do you know? Is that your numbers?
I think it's happening in other counties also.
Yeah.
I mean, Franklin had a very large backlog.
Yeah.
Obviously, the islands and Essex, it's not going to be that big.
The two, mentioned, of course, the two part-time prosecutors, Doug DeSabato in the islands and my old friend Vince Aluzzi in Essex County.
Mm-hmm. And they're both hard-working guys, but in fact, don't have the same numbers that would cause a judge to, en masse, clear off a docket.
Yeah, and with the pandemic situation, I can only assume defense lawyers like speedy trial. Hey, I'm not getting a speedy trial. I can only assume that argument was being made pretty regularly.
Yes, it was. And
with some success by defense lawyers?
No.
Or not really?
No, because the judges saw it's not the state
Nothing.
denying a speedy trial right. It's nothing that the state could do. It was the pandemic.
An act of God or whatever.
Pretty much. And so, and because everybody was in the same boat, the court said, no, well, this is not the way to deal with a pandemic.
Yeah.
And although the court slowed down, there weren't court dates to hold people's feet to the fire.
Yeah.
But there also wasn't a lot of outside of the court extrajudicial movement on any cases unless it really, really benefited a defendant. If they were could plead and then be released from pretrial incarceration or something like that.
So
We had some cases close.
arraignments kept happening,
Yep.
just not obviously not in court actually.
Mostly over the internet.
Yeah.
Yeah, and but sure, I mean,
What are you going to do?
Police are still on duty trying to protect
Sure.
the public, and sometimes they, the numbers were down, but sometimes when crimes happen and victims are victimized, you have to make the arrest and you have to bring them to court and you have to start the process.
Yeah, I'm recalling a typical, nothing's typical, but a Monday arraignment day, 30, 40, 50 cases. Does that still sound like or is that a little high? Is that high?
It is now, and the system is different now that it's, again, more online, and the courts.
So it doesn't have to be hooked on a certain day. It used to be Monday was the main arraignment day.
Right. And now days are assigned to different departments, so that they know which date in the next 3 or 4 weeks to ticket somebody or give a citation for.
Yeah.
And but there's pretty much arraignments every day now. But
Interesting. Jim, quality of judges, I'm sure you're not going to beat up on any judge by name, but as a quality, just in your long career, I guess I'd ask you the same about defense lawyers and prosecutors. You think the quality of all the different actors here has been stayed about the same, gotten better, worse?
Well, when I started, I looked up to the knowledgeable, experienced old people on the bench that were seniors to me and mentors, and now I'm older than quite a few, and had been a peer with a lot of the folks that are on the bench, and there's been some appointments lately of people younger than the retired Franklin County State's Attorney. Yeah, but I think the quality is the same, if not better, because there's a little more transparency and oversight. There's always an email happening when some judicial officer is up for retention, goes out to the bar who may have practiced in front of he or she, the judge, for comments.
Lawyers have to come up, or I guess something, judges come up for review is it six years?
I think it's every 6 years.
Every 6 years.
Yep. And there's a public comment availability, and the bar will send
Would you get involved in that? Would you?
Oh, yes.
Yeah, for sure.
Yeah,
including where there's some cases you said, nope, I think this person, not a good judge, should not get another term. That ever happened?
I don't think I did do that. No.
Boy, that sounds like that would put you in a bit of an awkward position.
Sure, of course, if it was a signed letter
if you were dealing
and all
with that judge.
But the admissions process and the screening and the judicial nomination board does a very good job to make sure that people who want to be judges have a good judicial temperament, have the knowledge of the law, and hopefully the experience in a trial setting to be comfortable enough to make rulings off the top of their head on the record and keep the trials going and keep the courtroom running and like that. And I think they've done a very good job. I haven't been, and I don't think Franklin County's had a judge that people really weren't happy with. That being said, the nature of trial work, it's adversarial. Sure. Half the people involved in the case leave upset. Sure. And they could blame the prosecutor, they can blame the defense lawyer, they can blame the judge, and a lot of times they do. Yeah. But it's typical, and that's what the Supreme Court is for, to review the case, especially in the criminal court, to see if there were judicial mistakes. Right. Or some sort of a misstep that affected the rights of the defendant or the outcome of the case that should be addressed. And I mean, even judges who I think are extremely competent, knowledgeable, and did a good job, the Supreme Court might say, here's an appealable issue that that should win the day. It's not a reflection on the judge necessarily, but just that. That issue came up, and the Supreme Court thinks it should have been addressed differently, if at all.
Right. So we're talking several thousand. We've got thousands of pending criminal cases here in Franklin County, population about 50,000. What percent convictions will you typically, I assume you've got a figure in your mind on that? Of
No.
all the arraignments you bring, all the charges you bring, what percentage of those people end up getting convicted?
Yep, good question. And we never really kept track of
Oh,
that
really? Interesting.
because about 85 to 90% of those cases are dealt with without a trial.
With plea
bargain
or
or
dismissal
dismissal in exchange for something, or just plain dismissal because there was an evidence problem or a change in the evidence. Witnesses, especially when there's a 2-year delay, witnesses move or die or forget.
Yeah.
But I've always told deputies when I hired them to not count a win and loss record for themselves.
Oh, is that right?
Don't do it.
Interesting.
Because the cases that go to trial are the weakest cases. I mean,
Right, I was
if
going to
I
ask you,
have
you mentioned
a
that
bust,
in our last interview.
right? If I have
So
a
that's the last thing you want to do is go to trial in a case. Is that the
Pretty
is that the
much.
case? Pretty much.
yeah, I mean, there's some cases that you're just going to have to.
Right.
I mean, we've had some homicides where
Sure.
the defendant wasn't going
Sure.
to admit and say, I'm going to take a life sentence.
Right.
They'll roll the dice on a trial, and that's
Sure.
going to happen.
Yeah.
But
But in
most
general,
of the
you don't
time,
want to go to trial.
no, because there's always something that can happen that you don't expect, or a surprise on the stand, or a change in heart of the witness, or a change in heart of the jury, a juror.
You certainly never know what a jury. I mean,
Right.
in all your trials, did you usually have a pretty good sense of what the jury was going to do? Were you surprised more than a few times over the years?
I think I had a pretty good sense of the jurors and talking to them and doing, in the selection process.
Yeah.
But I had been surprised.
I'm sure.
I've had jurors say, they could be, blind to who the defendant is and just by the facts decide whether the case is proven and whether or not the state met their burden, and therefore they can give me a guilty verdict. And then after a couple days of deliberation, have a juror say, the defendant's so young, I can't be part of this,
Interesting.
and just not deliberate.
Would you ever talk to
causes a
jurors
mistrial.
after the verdict came out? Is that something you
It's rare, but you can do that.
you can do? That's not unethical to do that?
No, because the case is over. You have to wait till the juror's done with their jury service,
Right.
at least for that round. I mean, some people can be selected again, and I don't know if I've written letters asking, like especially early on, I write a letter to the jury saying, was my case clear? Did I make myself known? Did my points made? Was I, did I present the thing understandably and well? What did you think it did right? What did just a performance review for the state.
And I guess judges can do. It's okay for judges to also talk to jurors after a case after it's done.
I think. Well, yes, I think they can.
I guess I can mention, I've just incredible to me. I've been up here almost half a century. Guess how many times I've been called for jury duty? How about one time?
Yeah.
And the judge in question, who I won't mention, but after we did our thing, did come in. He was interested in our feedback and stuff. Hopefully that's okay to do.
Right. I think the rule I was under, I had to wait to make sure, I didn't send out a congratulations on a great verdict type of letter and then have them come in for another trial the next week.
Yeah.
But after they're done with their tour of duty, so to speak, then I can write and inquire and see. And
I would
done
think
that in
that
the past,
feedback
but not too often.
would be interesting. And
Sometimes, and sometimes, I mean, I've had jurors stop me leaving the courtroom and let me know why the verdict happened one way or the other.
Interesting.
Especially if the juror didn't think, they weren't really confident in the way they voted.
Right.
But
obviously, a trial can be a murder case is a ton of work. But is that something you would still get into, or is that kind of the last thing you want to do happen in your many years as a state's attorney? Was it kind of fun to use probably a bad word to have a trial once in a while, or
no? It's not a bad word, and it is a lot of work, but it's what a trial attorney wants to do.
Yeah.
Like we said a moment or two ago, sometimes the economics of bringing witnesses in and analyzing evidence and getting things all set is like producing a play and getting everybody to to get on stage at the right time, remember their lines. They're it's hard work, and it's involving people, and usually in a highly emotional situation. So something always surprises you or goes wrong.
I bet. Do you keep track? How many trials have you?
Nope.
You don't.
No, that goes with the not counting because, like I say, we plea bargain the strong cases, and then it gets to the weak cases where a defendant says, "I think I can beat this," or "My witness is going to speak in complete sentences, and the state's witness, can't and isn't going to be believable." They're going to acquit me. I'm going to go to trial. And so it's the weakest of the cases that actually go to jury. And, like I said, my deputies should not count because they're starting with a skewed apples and oranges kind of a set of cases to select from to see. And you can't measure yourself whether you're a good trial attorney or not by the wins and losses.
Do all your former deputies, would they all do some trials, or would some deputies just not do any trial?
Everybody goes to trial.
Is that right? So you wouldn't hire someone who said, "Hey, I'm a good lawyer, but don't throw a trial at me."
I can't.
They've got to be able to do that.
I would not have the room for a person. I can't just have
able to do that.
A law clerk.
Right.
The government is limited.
Right.
I only had so many position numbers to fill in for attorneys or for victims advocates or for support staff. And everybody had too big of a job to do. I mean, everybody handled more cases than the Vermont Bar or the American Bar Association says is realistic for their position. We're all stretched very thin, and they all work way too hard.
Sounds like it. Obviously, some deputies are into doing trials, obviously more than some of their colleagues.
Oh, sure. Well, that's just personal preference. But everybody goes to training every year for trial advocacy. Everybody has cases that have a potential of going to trial. Everybody knows how to draw a jury and present a case to the jury, and how to act and have a good courtroom demeanor.
So obviously a key part of the job, obviously.
Yeah, that's it, and that's how. That's what I looked for when I would hire deputies. I don't think any office has room. Maybe the largest county, but has room to have a specialized, like a pellet, or just a paper pushing deputy who would answer motions but not have to go to court. Things like that, or just review cases and decide whether or not to bring charges. There just isn't room.
When I look back, just reporting correctly, there's still a few cases. Geez, that was not sir. I did not do a good job on that story. Why did I even get into that? Did you lose sleep over, again, dealing with hundreds, thousands of cases over the years? Some of these, did you lose sleep over some of these? Or some, yeah.
Some you do. You can't let go. Some, but I learned very early on that you have to have the professional detachment. You do your best, and you let the outcome happen, and you move on. You can't go back and say, "What if I did this?" or "What if I did that?" or "It coulda, shoulda, woulda." No, you can't do that. Or A, you never move on, and B, that's sleep lost that really isn't buying you anything, because once the gavel comes down, the case is closed.
Any one particular disappointment, or I guess you maybe answer the question. I guess it sounds like it sounds like you had a great career. It sounds like you're pretty content, pretty satisfied with your. I
had a long career, and I think I did my best. I tried to work hard for the victims of criminal acts, and just that's all I think anybody could ask of me, is to do what I could at the best level I could. So we tried.
And down to our last seconds here, criminal justice system, again, it's still floating above water at times. It just seems like so many of our institutions, to me, are just barely hanging in there, but hanging in there at least.
I think it's experimenting with this new, bail review and lack of, no incarceration, refining the the punitive aspect of the criminal justice system, and whether that'll work or not is yet to be seen.
Yeah.
So we will see. I hope this is a learning curve for justice in not just Vermont, but in pretty much the whole country.
On that note, we'll stop. Jim Hughes, thanks a lot for the additional time. Jim Hughes, the former Franklin County State's Attorney, guesting with us here on Northwest Access TV. Thanks to producer Alan Cunningham. I'm Richard Cowperthwait. We'll see you next time.